You are presented with the option of a bet. There is a coin, and if it is flipped by the person who is presenting the option of the bet to you, and if it lands on heads, you get $200. If it lands on tails, you have to give them $100. Do you take the bet? This is actually taken from a very famous example of a bet which took place a number of decades ago. And one professor presented the bet to another professor, and the other professor said, "No, I'm not taking the bet." And the professor who presented the bet later asked, "Well, what if we were to do the exact same bet 100 times? Would you take the bet?" And the other professor said, "Yes, I certainly would, because I would be 5,000 Rand up." And he's correct, because if the coin is an ordinary coin, it would 50% of the time land on heads, 50% of the time land on tails. And in that case, in the 100 throws, approximately 50 of them would be losing and approximately 50 of them would be gaining. But the gain was double the loss, which means that there would be a gain of $10,000 and a loss of $5,000, and so an overall gain of $5,000. And in investment theory, if something is overall a gain and you repeatedly engage in behavior which engages and pursues, educates the gambling in such a way that you will consistently pursue good bets like this, then you're consistently over time going to win even if you lose in the moment. But there's a problem with this, because that problem is that people do not think rationally like that. Except some people do, and I'll get into that in a moment. There's something called prospect theory, and it was developed by Kahneman and Tversky, and it's the most cited article in one of the major economic journals, and it's decades old by now. But it deals with the fact that when people see a potential gain, they think that it will bring them a certain amount of happiness. But when they see a potential loss, they consider that the loss, it will bring much more despair and unhappiness to them. So a gain has to be quite extensive to offset a potential loss, and the 2-to-1 scenario given generally isn't. But when you look at someone putting money into lottery or into insurance, generally speaking, they are, in the first case, trying to gain a great gain and giving up a small amount in a definite loss, and in the other case are giving up a small amount to avoid a great loss. Now, the flip side of the scenario with the $100, $200 example is the example of a gambler. Now, a gambler is said to be someone in many cases who would, if they are in a losing streak, will double up. They will try and put in enough money to win back all of their losses. Now, it might seem very sensical to you to do this, but it's actually irrational. So it's sensical, but it's irrational. And this specific scenario is something which is very important when it comes to attorney-client relationships. Because an attorney, generally speaking, deals with hundreds upon hundreds of cases over their career. And so when they look at a matter, they quite often will look at it with a different sense of risk than their client does. Because it's one of many matters, and they think, well, if I have a 50-50 chance here, if I win, this is the consequence. If I lose, that's the consequence. Winning is better than losing. And if I'm winning $200 and possibly losing 100, it's worth it. The problem is that for the clients, they're not dealing with 100 matters, they're dealing with one matter in most cases. And so if the attorney takes a very good decision risk-wise, but it turns out to have bad effects for the client, it might have extreme effects on the client overall and cause a breakdown of the relationship. It could cause suing, it could cause reports to the Law Society, and so forth. And it's very important in regards to this to realize that an attorney is a creature of instruction. They are there to follow their client and to guide them. And I often use the example of an attorney being a bit like a scribe who can read and write on behalf of a client who is illiterate to the law, and as a guide who knows the territory and who can move through it and interact with it for someone who can't. So that's what a lawyer does. And a gentleman by the name of Jordan Peterson, who's a clinical psychologist and a professor of psychology who's quite well known and a best selling author, um, gives an example of how he does his job without taking it home with him. And what he does is he lets his clients solve their problems. He tells the truth to them, he interacts with them, he uses his knowledge, but he lets them solve their problem with him helping them. And that's what a lawyer is supposed to do. So your attorney-client relationship is very important. Another thing which is quite important, and I think Nicholas Lloyd has a very good video on this on his YouTube channel. He talks about 3 rules of battle, and they're quite grounded because I've read quite a lot about warfare and battle and also watched many things about it, and a lot of it correlates with what Machiavelli would say or like Sun Tzu would say in the art of war or things like that. So it makes a lot of sense, and I think that these are 3 of the most essential things in battle, and I think it also applies to law. And the things in question are, the rules in question essentially are, the first rule is to always use the minimum amount of force. And this is very much a Sun Tzu sort of thing as well. And the reason you want to do that is the more force or more resources you pour into something, the more you're vulnerable in other areas or you're vulnerable in a loss. So you pour in the minimum amount that you need to succeed, and you don't pour in more. I'm not saying you shouldn't have ironclad contracts or pleadings, you should, but you use the minimum amount of force. So if it's possible for a client to simply talk to the other person, having been informed of what the law is and their rights are, that's great. If you need to escalate and write a letter, in accordance with the circumstances, then that's also great. But bear in mind that if you're writing a legal letter, someone who receives a legal letter doesn't just faint and have a heart attack. They get an attorney, and then it becomes this whole legal clash, rather than something which can be sorted on the ground with the best interests of the parties in mind. And once it becomes a legal clash, it can escalate further and further from that. So it's something to be aware of. And also, bringing in further force means more escalation. There's one example which is sometimes used, that when you enter into a war and you develop a new technology, within 15 years that technology or weapon will be used against you. So you need to be aware that the more you escalate, the more you use these things, the more a matter can snowball out of control. It's important to keep things on the minimum level of force at all times, but to pursue that level of force nonetheless where necessary. And it's therefore very important to have a good relationship with your clients while doing these things, because quite often that minimum level of force involves them rather than their attorney. And when it involves the attorney, it needs to be done in the right way, and with in mind that an attorney and a client might have different senses of risk, and the attorney's sense of risk is not always the best idea because they're dealing with very many matters, and they might not be aware of the increased sense of risk that the client is feeling in a matter compared with them. So let's have a look at people involved in a matter. You need to know what's known about your client, and you should know your client relatively well as a person and their psychology and their sense of risk and so forth. What is known about the opponent and about other parties and witnesses as well, obviously. And who are the affected parties of the matter and how are they affected, including contact details where relevant. And this is quite important. You might find that a matter has many ripples and many effects on other people, and people who might not have locus standi, a place to stand in court, or who might actually have it and you don't realize it, are going to be affected by the matter as you move forward. and you need to be very careful about how things go about in that matter and in that manner. And you need to know what your matter is in a nutshell. And you can summarize after taking full instructions, possibly write a bit in the beginning or before or when seeing a client. And a client can, for instance, be told to give a very short summary of their matter, for instance, in 5 minutes or less. So you get an overview of the matter, and it's quite important to always have that on hand, or at least in your mind. And you need to know which professionals are working on the matter and their contact details, including advocates, attorneys, candidate attorneys, sheriffs, judges, clerks, etc. And in the case of where something is going to court, you need to know the date and time it's at court, which courtroom it is, which court it is, where it's located, and which judge it was before, along with any judgments which are made and anything that really happens in court of importance. As for the attorney-client relationship itself, which I was alluding to a lot earlier, you need to really focus on knowing what's happening with it. And lots of these sorts of things, you're not asking direct questions of the client. You need to observe and take things in. And you need to know, without going into the details of their matter, what does the client expect and want to gain out of the attorney-client relationship. So what's their underlying desire out of the matter? And that's very important, because you can very often go with what someone says they want out of the matter when it's not what they want, and you can accidentally sacrifice what they really want out of it. Though at the same time, you need to have good communication with your client in any case. What expectations does the client have of the whole process? What is their reason for being there, specifically seeing an attorney on that day? Why has the client chosen to go with this particular firm? Is the fit of the clients and attorneys needs and resources, abilities, expectations a good one? Is it the right fit? Has the client been to an attorney before? What did they see an attorney for? What was their experience with that attorney? And what did they like and what did they dislike? Did they have problems with that attorney? Were there any disputes about fees and work done? What was the end result of the matter? What result did the success or failure in it have? Why are they using their current attorney or prospective attorney rather than that attorney on this matter? Is there anything in that matter which could affect their current matter? Has there been another lawyer, attorney, or figure involved in dealing with their current matter? What's happened in relation to that lawyer, attorney, or figure? And are all fees paid up? Are any documents outstanding? So those sort of basic things are very important, but you need to really read between the lines in all things happening with the matter, and to truly get an understanding of who your client is and who the other people involved in the matter are, because going to court or involving the law is an application of force, and force is an application of violence. It's very polite violence, it's very civilized violence, but at its core it is violence. And that is what you're dealing with. You're dealing with a conflict. And you need to be prepared for it, and you need to have the right strategies involved for it. Nicholas Lloyd's second rule of combat is to always stay in contact with the enemy. Because if you're in contact with the enemy, you know what they're doing, and you're able to counter it. If you're not in contact with your enemy, you aren't able to. And I find that the best way to stay in contact with the enemy is to stay in contact with the person whose enemy it is, with your client, because they will be your boots on the ground. They understand what's happening. And Machiavelli gives a wonderful example of a way in which a conquered territory can be maintained. And that way involves the prince or the ruler moving to that area, so that whenever an attempt is thought up to overthrow the state, the prince can be there to take action against it on the ground immediately. And it's quite important, therefore, to keep channels of communication open with your client who's on the ground and dealing with the matter. And an attorney has to speak to the attorney on the other side. You have no option about it unless the other side doesn't have an attorney. But the client can talk to the opposition directly, and this is quite a powerful thing. is not powerful in the sense of the attorney acting through the client solely instead of speaking to the other attorney, but rather it's powerful in the sense that the client will often have a better understanding of the matter on the ground than an attorney does in their office. And every time an attorney writes a letter, it can have the effects of escalating something and moving it closer to litigation, while a client looking at a matter can often give facts which the attorney is unaware of. So, in my experience and understanding, the best way to stay in contact with the enemy is often by having a good ear to the ground to hear what your client is saying to you. Now, sometimes clients have been known to send way too many messages to their attorney and upset the whole relationship, and attorneys talk about how they will then bill their client for the time of sending messages, and obviously there's a balance involved, but it's very important to keep lines of communication open with your client as an attorney, because the consequences of not doing that are quite extensive. And obviously, if you are dealing with the matter, keeping in contact with the enemy is quite important as well, and often that will be keeping in contact with the attorney on the other side and trying to narrow down the issues and continually work away at it. And this reduces time in court and the time a matter takes quite often. So it's important, but it's also important to be strategic about things, not to be surrendering to the enemy, but to be continuously skirmishing with them in a sense, but politely, of course. And Nicholas Lloyd's third rule is to fight your enemy at your range. He gives an interesting example of a child who's being beaten up in a playground by a bigger child. And then the child tries to punch back, but it doesn't really help because he's being held down by a child who has longer arms than he does. And if that child were to want to win, he'd need to lean closer to the other guy and punch from his range. Another example he gives is mortar ranges, where if one side has a mortar range of 3 to 5,000 feet or something, and the other one has a range of 2 to 3,000 feet, the one with the range of 2 to 3,000 feet should always be trying to fight in their range rather than the opponent's range. And so you need to be fighting in your own range or on the ground which you're used to, in a sense. And in Saul Alinsky's Rules for Radicals, which is a handbook for people who want to upset or upset authority, but which is also quite useful. It's a sort of like the opposite of Machiavelli's The Prince. It's almost a guidebook for people who want to have an uprising, but he mostly keeps things legal and the things that he advises. But he gives the example of you should always have you and your supporters in their comfort zones and the people who you're going against out of their comfort zones. So basically, he's saying you should be fighting in territory which you understand and can deal with, and your opponent should be kept in territory that they don't understand and can't deal with. So, to do this, again, your attorney client relationship is incredibly important. And it's important to understand what your client can deal with and what they can't deal with, and what's good for your client and what's not good for your client, so that you can consistently fight a battle on your terms and the terms of your clients without in any way violating your duty to be collegial to the attorney on the other side and to be upstanding and not to be dishonest in any way. But it's important to control what fields of battle things are being fought on in such a way that it's to the maximum benefit of your clients. My name is Marc Evan Aupiais, and nothing in this presentation consists of legal advice, and it should not be relied upon as legal advice in any way. For that, please contact your attorney and make an appointment with them and brief them with all of the nuances of your matter. Thank you very much.